Hi everyone, I'm Jen Podemski, and I just wanted to present the following interview to you in an effort to expand awareness and utilize some of the tools and resources that I have that I've grown up with, one of them being Russell Diabo, who is my stepdad, but also very knowledgeable. And I guess what I'm about to share with you is kind of a snippet of some of the things that we talk about around the dinner table every so often, and especially with the rise of the grassroots movement, idlenomore, I feel it really necessary to address some of the bigger, more complex issues from a very simple perspective, because now more than ever, and I'm sure many of you Native people out there can relate to this. I think a lot of racism is coming our way, ignorance, a lot of fear is coming our way because of the movement, this incredible revolution that's happening. And it's important that we don't get lost in our explanations. I sometimes feel really inundated by questions and I don't know how to answer them. So this was my way of, I guess, giving something to the greater movement, not just Idle No More, but the greater movement, the Indigenous movement of the world, coming up and resurging. And I would love to see a Canada, I would love to see a world that worked hand in hand and in partnership with its Indigenous people, and together we can become stronger. So that's what this is about. I won't go on anymore, but this is Russell Diabo, and I hope you enjoy it.
Russell Diabo. I'm a member of the Mohawk Nation at Kahnawake, and my experience is I've got a Bachelor in Arts and Native Studies, and I've worked with the Assembly of First Nations 2 times, the National Indian Brotherhood 1 time, and I'm currently working with 3 bands in Western Quebec, but I've worked with bands and tribal councils in British Columbia as well, and that's basically my experience. I have practical work experience dealing with First Nations policy. This is an issue around terminology. People need to be aware that within the Canadian government they use terminology to describe different people. For example, Canada's Constitution of 1982 talks about the rights of Aboriginal peoples, meaning Indians, Inuit, and Métis. And Canada has a history of the Indian Act where, Indians have been identified, all the different nations have been described just as Indians, even though there's about 50 to 60 different Indian nations. And of course there's the Métis, who are mixed bloods, mainly from the prairies, but there are others who identify elsewhere. And of course the Inuit up in the north. But Canada has now introduced this term called Aboriginal Canadians, where they're lumping everybody together and focusing on Canadian citizenship and downplaying the Aboriginal side. So First Nations is a term that was developed in the 1980s by status Indian organizations to address the concept of 2 founding nations that was being put forward by Canada, meaning the French and the English-speaking peoples, saying that they were the 2 founding nations. So First Nations was coined to say, no, we are the First Nations. The English and the French came after. I think that I would describe the situation of First Nations in Canada as being one of being in a colonial situation, because Canada is still using the Indian Act as the main statute or law to control and manage Indians, status Indians or First Nations. And that law goes back to 1876. And although it's been amended from time to time, it's still being used to control and manage Indians, like I said. And that's a colonial relationship. That's what has kept Indians in poverty and kept them from enjoying the benefits of their lands, traditional lands and resources. And even having a say really in how their reserves are managed, because under the Indian Act, the minister has 75% discretionary authority over Indians. What people have to understand is there's 2 parts to the Constitution. There's the Ode part in 1867, when Canada got its Constitution from England. It was called the British North America Act of 1867. That's where the powers are divided between the federal government and the provincial government. And the federal government under that constitution has powers over Indians and lands reserved for Indians. So they have exclusive legislative authority to pass laws over Indians and Indian lands. And that section, it's called Section 9124. And that's the law that they use to create the Indian Act. Now, provinces have Section 92 powers, and they have powers over natural resources and education and wildlife and things like that. So that's where First Nations, Indian First Nations, get caught in the middle between the federal and provincial jurisdictions. Now, in 1982, a new constitution was adopted with Section 35, and that's very important because that's supposed to be the future relationship of Aboriginal peoples, including Indians or First Nations, was supposed to be based on Section 35. And that, of course, means that they have to recognize Indigenous laws and work with, Indigenous peoples. But Canada had constitutional talks in the 1980s and didn't. Those were supposed to identify and define the meaning of Section 35 of Aboriginal treaty rights, which are recognized and affirmed according to the Constitution. Those talks ended in failure, and so there's been legal and political uncertainty as to the meaning of Aboriginal treaty rights, Section 35 rights. The courts have started to lay out legal tests, which require a lot of evidence, which costs millions and millions of dollars to prove, and most First Nations don't have it. So the government has been taking advantage of that by coming up with unilateral policies on land claims and self-government, and they're basically making offers at negotiating tables, take it or leave it offers, knowing full well that most First Nations can't go to court to challenge the government, so those become the only game in town. And those agreements are meant to, restrict, limit, or terminate First Nation rights in the long run. And so, again, that's a colonial relationship, and they're using, like I said, 9124 instead of Section 35 as a basis of their relationship with First Nations and other Aboriginal peoples. I've written about Harper launching a First Nations termination plan, and my contention is that the government's objective is to empty out Section 35, of the Constitution, recognizing Aboriginal treaty rights, to emptying that out of any legal or political meaning by getting First Nations to sign on to agreements, basically to self-terminate their rights, to compromise their rights, their Section 35 rights in exchange for these rights defined in these agreements. And the terms and conditions of those policies, basically turn First Nations into municipalities. If they agree to them, they have to give up their reserves, change their tax status, basically become a municipality within the Canadian Confederation. And they're doing that through what's called this results-based approach to these negotiating tables, comprehensive claims and self-government tables. There's 92 of them across the country, because I've been informed the Blood Tribe was one, making it 93, but they've pulled out, saying they're not negotiating a self-government agreement anymore. So that leaves 93 tables across Canada, representing hundreds of bands across the country. And the government's results-based approach is to say either, agree to our policies and settle under them, or we're going to drop your tables from negotiation. So that's one thing they're doing. The other thing they announced, these are all announced on September 4th of 2012, the results-based approach. They also announced they're capping and cutting the funding to provincial territorial organizations, which will cripple their advocacy, the ability of the chiefs to meet and plan to deal with government legislation and policy and other actions of the federal and provincial governments. They're also announced that they're getting rid of advisory services for tribal councils and bands, which will cripple their ability to analyze, legislative or policy initiatives or economic development occurring on traditional lands, impacts from that. So they're doing that on top of this suite of legislation, where they have about 8 bills amending the Indian Act. Even though the Prime Minister said at the Crown First Nations gathering that they weren't going to unilaterally get rid of or amend the Indian Act. So obviously he didn't keep his word there, because after that Crown First Nations gathering in January of 2012, they've introduced these bills into the House to amend the Act. So between the suite of legislation and the policy framework the government has, it amounts to terminating, eventually terminating the rights of First Nations, the collective rights. Well, the treaty-making process in Canada goes right back to contact, because the earliest treaties are the wampum belts. For example, the two-row wampum that the Haudenosaunee entered into with the Dutch and then the British, that evolved into what's called the covenant chain relationship. And there was also a series of peace and friendship treaties that started in about 1752 out in the Atlantic, but also from 1760 to 1764 in what's now Quebec. There were peace and friendship treaties bringing in the former First Nation allies with the French into the covenant chain relationship with the British. And, in 1760, that's when those peace and friendship treaties started. Then in 1763, of course, we have the Royal Proclamation of King George III, which, recognized the pre-existing rights of Indians and described the colony of Quebec, Rupert's Land, and Indian Territory. So it laid out, some territorial definitions. But it also made it clear that Indian lands could not be taken without Indian consent. There had to be public meetings, for that purpose. So that started the basis. And they also said in the Royal Proclamation that Indians couldn't give their land up to anybody but the Crown. So in other words, Indians couldn't sell it privately to white settlers or anybody. So in there, Canada, the British took up a fiduciary obligation to protect Indian interests from trespasses of settlers, which they failed miserably at, but those promises were made in the Royal Proclamation. And those are reconfirmed in, I would say, a major treaty in Canada, 1764, the Treaty of Niagara. And that's a wampum belt that you may have seen. The chiefs, they had it with them when they tried to get into the House of Commons on December 4th. There was a replica of that treaty belt. And that represents the Treaty of Niagara, where they brought together the Haudenosaunee and Anishinaabe nations into an alliance with the British. So that started the treaty-making process that occurred throughout Ontario, through the pre-Confederation, before 1867 period, and right up to the numbered treaties, which cover the prairies, treaties 1 through 11. So those are considered to be sacred agreements from the First Nation side with the Crown or the government. And with the new Constitution coming in 1982, Canada has become the successor state from England to honor those treaties, because there was a court case where the Treaty First Nations tried during patriation to stop the patriation process, but Justice Denning in the British courts issued a decision basically saying that Canada had a right to patriate the Constitution, but they should honor the treaties as long as the sun shines and the grass grows. And so the British Parliament passed the Canada Act, which gave Canada its Constitution Act 1982, which was signed into law by the Queen on April 17th of 1982. And that's where we have to, I think, agree as to the meaning of what Section 35 is, because Canada's been trying to dictate it from their side. And I think we have to push back and say, no, Section 35 recognizes our inherent and Aboriginal and treaty rights. I guess you could use that as a metaphor. I mean, it's like saying somebody can stay in your house and they have a room in that, and all of a sudden they take over the whole house and you're left outside, with the doors locked or limited entry, where they're dictating the terms in your house. And that's basically how the treaty relationship was breached, where Canada just, made treaties and then ignored the treaties and applied provisions of the Indian Act instead. And that's what's happened historically. And of course, that was all under 9124, that section of the old Constitution, the BNA Act. So Section 35, I think we have to argue our interpretation of it, where we can reconcile on how to coexist. And a good way to look at what does that mean is look at the report and recommendations of the Royal Commission on Aboriginal Peoples. I mean, they spent $55 million on looking at the whole scope of the history to the contemporary situation, and they've made some good recommendations, which the government just shelved in the 1990s and never looked at it. And I think it should be brought out because it's still a good resource book for Aboriginal and non-Aboriginal peoples to know the history and the recommendations they made about, how to solve some of these problems. Right. And that's a good source. And then also on top of that, now we have the United Nations Declaration on the Rights of Indigenous Peoples that has articles in there that form an international standard of human rights that Canada should be measured against in terms of its domestic policies, because there's big gaps between the articles in the UN Declaration and Canada's land claims and self-government policies, and Canada's continued reliance on imposing the Indian Act. So I'd say the Royal Commission on Aboriginal Peoples report and the UN Declaration on the Rights of Indigenous Peoples are two source documents that people should familiarize themselves with, because in there are the answers for reconciliation. Well, there is a United Nations Permanent Forum on Indigenous issues, and every spring thousands of Indigenous peoples go there to that permanent forum. And there are themes that are talked about. Last year's theme was the doctrine of discovery, where Indigenous peoples came and, denounced that racist property concept, because that was the doctrine that Canada relies on to claim this country. But it's also the doctrine the United States relies on, and it's relied on in the whole Western Hemisphere, in Central and South America, by settler governments.
Right.
And
you mean sort of removing it from the system, that the idea that someone discovered this place?
The first recommendation of the Royal Commission on Aboriginal Peoples was that racist doctrine and the doctrine of terra nullius, empty territory. Those doctrines should stop being used by the governments as justification for the lands that they occupy now. And they should also stop using the arguments in court that that's a valid legal defense to claim ownership of Canada. So that is a recommendation the Royal Commission on Aboriginal Peoples made. But it's also being discussed at the United Nations in the Permanent Forum because it affects other countries beyond Canada. Bill C-45 was an omnibus bill, and I think the reason why it's been the focus of the idlenomore movement's opposition to it is that it was an omnibus bill. It throws so many amendments to so many other federal laws in there that it's difficult to analyze, for one thing. But there are two prominent parts of the bill that people are objecting to. One is it amends the Indian Act to reduce the thresholds for designating lands on reserves to be used for economic development. Right now you need a majority of the members, to vote in a referendum approving lands to be designated for economic use, and it requires the cabinet to approve it as well. They're reducing that to say it's just a majority of whoever shows up at a meeting where a notice is given. So it could potentially mean only 10 people show up and make a decision affecting the whole reserve. And also, instead of the cabinet having to approve, only the minister has to approve. So it could be a deal between the minister and, community, where they may want some lands adjacent to a municipality to have some of it used for economic development. And that could happen fairly easily without, if the members don't all show up at the meeting, if they don't see the notice or whatever. So they're relaxing that threshold. But I think one of the bigger ones is changing the Navigable Waters Act, because Canada has, federal powers over navigable waters. And they're removing thousands of lakes and rivers from environmental protections and only naming a few. So that's got First Nations concern right across the country, because that has implications for Aboriginal treaty rights, for fishing and for habitat, and the basically unbridled development that the Harper government's promoting across the country. So those are the two main aspects of Bill C-45 that the opposition of idlenomore is focusing on. Well, my observation of it is it's got a lot of grassroots people involved who haven't been involved politically before. I think even the term idlenomore means that they were idle, they weren't involved, and now they've gotten involved. And they're doing things like rallies and flash mob brown dances, and there's even a blockade of a railroad right now as we speak. and there's been some sporadic blockades. But it's involved a lot of the grassroots of all ages, but particularly the youth, because I don't think we've ever had. There's been movements like this across Canada before. It happened in 1969 with the White Paper when the Trudeau government proposed terminating Aboriginal treaty rights. Then that's when there was movements across Canada which created the modern organizations that exist. The provincial First Nations organizations, and the National Indian Brotherhood was formed, which turned into the Assembly of First Nations later. But also, it happened in 1990 when what the so-called Oka crisis happened. When a municipality wanted to expand a golf course into Gunnesadagi, a Mohawk community. There was a lot of political activity outside of the Mohawk communities right across the country. A lot of political unrest and demonstrations and blockades that are occurring. And the idlenomore movement is similar to that. It comes in cycles, it seems. And this cycle, there's new technology we never had before, like smartphones, and we have social media like Twitter and Facebook. And we have a lot of, our people are very savvy at adapting that technology to organizing and doing activities together. And that's what we're seeing the idlenomore movement is using that technology very effectively. But, what they have to do, so far they've been kind of shallow in their analysis of what we're up against. What I call the termination plan, I don't think they fully understand the full scope of that the Harper government has, that they're implementing with the legislation and their policies. And the difference between 1969 was it was a statement of principles, but in 2012 it's a plan, and they're implementing the plan, and it's way beyond Bill C-45, which is what most of the idlenomore movement activities have been organized around. And they're also organized around now in support of Chief Teresa Spence from Attawapiskat, her hunger strike that she announced, because the two kind of happened at the same time. And once she announced her hunger strike, the idlenomore activities seemed to focus on her demands, which are for a meeting between the Prime Minister, the Governor General, and First Nations representatives to talk about the intent of treaties. And she said that she thinks that will take a week or two to sort out. And so she's been on hunger strike for, I think it's 20 days today. And she's invited MPs and senators as we speak to meet with her today on Victoria Island. And I know First Nations leaders are coming too. So, it's hard to say where this is going to end up. But I think the positive thing about idlenomore is it's activated or engaged a lot of grassroots people. I'm hoping they'll stay engaged and learn more about what they're facing, because the leaders can't do it alone without the people. And the problem is the leaders have been there, but they haven't had the muscle, the leverage to get the governments to listen. But now we have a large national social movement with our people active and frustrated and angry, some of them. So far it's being peaceful, but if something happens to Chief Spence, or if the meeting doesn't come up with solutions to change the poverty and the breaching of Aboriginal treaty rights and everything that's wrong with the relationship in Canada, I'm not sure where it's going to go as a social movement, because it seems like a lot of people are awakened now. The Harper government, I guess, can be thanked for that with their stubbornness and intransigence, because they have seemed to help spark the people to move in opposition to him. So I don't know where it's going to end up, but I don't think we can go back to where we were before this happened. Well, during the constitutional talks, what was called for was recognition of First Nations or Aboriginal peoples as forming a distinct order of government in Canada, distinct from the provincial governments and distinct from the federal government, with recognized territories and with recognized areas of jurisdiction. And the Royal Commission on Aboriginal Peoples even recognized core areas where Aboriginal peoples could exercise jurisdiction right now. And I think that's why I referred to those documents. Reconciliation could occur if each First Nation has a framework to get out of the Indian Act from the bottom up rather than the top down, because that's what all this legislation is. It's top-down imposition of national standards and prescriptions, which I don't think will work because the Indian Act has affected 633 Indian bands in different ways. Some have embraced the Indian Act provisions and some have resisted it. So you have to look at the local facts of each band, and they have to decide where they want to go to repair the damage the Indian Act has done to their community and their families and themselves. The residential schools being part of that, but the Indian Act went far beyond the residential schools. It controlled every aspect of Indian life in terms of even having Indian agents telling the chief and council what band council resolutions to pass and what they can and can't do. For a while, the Indian Act even banned ceremonies and made it illegal for Indians to hire lawyers for land rights, and forced our traditional governments underground. So that's why a lot of traditional peoples, had to hold their meetings in secret and their ceremonies in secret. And the RCMP seized a lot of material culture at the time. So to reconcile from that, it has to go beyond looking at the impact the residential schools have had to the impact that the whole Indian Act has had on our ability to make decisions and on our culture and languages. And to reconcile that, there has to be recognition of internal sovereignty for First Nations to be able to solve their own problems and be able to work with the other governments in Canada in a more equitable way instead of in a colonial way that it's been in the past. And that means, like I said, agreeing on what Section 35 means, a definition of Section 35 by consensus, not being imposed, because right now they're saying there's nothing in there except what we give you through agreements. It's an empty box. We're saying, no, it's a full box. It contains all of our rights. And until we can sort that out and reach some consensus on that, we won't have reconciliation in this country. We have to get rid of the colonial past by building on Section 35 and leaving 9124, the BNA Act, behind us. I think the youth have to, and members of First Nations in general, have to learn their history. For example, how was their reserve created? What did the Crown agents do? Did they come and make promises? Because I know some reserves were created through the treaties, but there were many other reserves that were created through other means where there aren't treaties, like in British Columbia and Quebec and the Atlantic. And, to know the history, because it's important to gather that, because you need that to come to the table with anyway to say how you've been treated by the Crown. But it's also important to have your history collected in case you have to make international complaints against Canada at the United Nations. They require documentation. But it's also good for you to understand, in terms of your own identity, how your community and your family had few choices, which have led to the situation, the contemporary situation many find themselves in, where they're no longer on reserve, they're in urban areas, their connection to their communities and families have been cut off. There's a history as to how that happened and why the poverty exists both in urban areas and on reserve. And it's systemic and it's institutionalized and it was controlled by the Canadian state. And it's a result of the Indian Act, the residential schools being part of that, but also denying rights off reserve to the traditional territories or treaty territories and letting non-natives move in and take over. And they benefit and enrich themselves out of lands and resources. Because in the end, Canada's a prosperous country because it's stolen Indian lands and resources. And it basically, by not recognizing Aboriginal treaty rights, First Nations are subsidizing Canada's economy because the compensation for, taking those lands and resources hasn't been given. And that's why First Nations are impoverished, yet all around them there's wealth in the cities of Canada because they're enriching themselves off of stolen lands and resources. So you've got to learn that history and how that works in order for building your communities back up and your nations back up and making demands on the federal and provincial governments for the kind of changes and accommodations to recognize, Aboriginal treaty rights. And, getting a good understanding on your identity, why you shouldn't be ashamed, about who you are, because it's the government that created the conditions we live in today. It wasn't our fault. We had no choice in that. We were forced. and they used the police. And in 1990, we saw they're prepared to use the army if we go beyond what they say our rights are. So it's going to take a collective effort across the country. Idlenomore has made a good start by engaging the grassroots people coast to coast. Hopefully that can keep up and become a learning movement, but not just a learning movement, a doing movement about, getting out of the Indian Act and developing your own constitutions, your own laws, your own ways of doing things. There has to be reforms, in the public school systems. The on-reserve schools, they're underfunded, and there's a big debate right now about, a federal First Nations Act. There's a lot of opposition to that because they don't feel that the federal government should be dictating the terms of education on reserve, or even First Nations children going to school off reserve. And also the education policy of Canada comes back, it's part of their self-government policy, where they're basically going to only delegate authority, not recognize First Nations jurisdiction. And that means that if you enter into self-government agreements on education, under that policy, you don't really have a say. You're just implementing somebody else's jurisdiction. So that's part of the movement, is getting those policies changed. The leaders have to demand that, but the people have to demand our leaders demand that from the Crown governments. Well, like I said, the Royal Commission on Aboriginal Peoples report recommendations is a good start to read, and learning the articles on the United Nations Declaration on the Rights of Indigenous Peoples. Because if we don't learn it and ask for it to be implemented, who's going to do it? It's really our responsibility to learn these things if we want that for ourselves and our future generations.
And what about going to law school or becoming a politician?
Sure, the more that stay in school and learn these professions, more and more there are Aboriginal lawyers coming out of the system. But we also have to learn our own laws, because there's 3 legal traditions in Canada. There's the French Civil Code, the British Common Law, and there's Indigenous law. And the courts do recognize it. But we've been very poor on researching our history and our customs and understanding our own laws. And we're really weak on that. But that goes back to the Indian Act, where we've been told what to do. So I think the Indian Act really destroyed our decision-making abilities a lot, because somebody was always telling us what to do. We have to relearn how to make our own decisions. That's what self-determination is about. And it's all areas of life, education and economic development, governance, all of that. We have to relearn what's been taken away from us.
Is it possible to do this in a peaceful, non-violent way?
Ideally, but I don't think Canada is going to change anything unless we affect the economy of the country. And ideally that would be peaceful. But, there's a lot of racism out there, and I know that the Canadian government has used the intelligence community of Canada to spy on Aboriginal peoples, especially protesters, even if they're doing peaceful protests. So, it's about the economic development of the country and the natural resources. There's about $600 billion worth of projects that Stephen Harper's promoting in the country right now. And First Nations are in the way of that, including pipelines, hydro development, mining, forestry. There's got to be a redistribution of the wealth there for things to be fair. And often that doesn't come peacefully, that kind of change. But without, redistributing the wealth that belongs to us, in terms of the natural resources in this country, I can't see us really changing the other things we want to do in our societies, because it takes money, to build the institutions and governance, educational systems, housing, social assistance, the things that are needed from our people. So I think it's going to be a tough struggle. I don't think it's going to be an easy one. And I don't think a lot of the people in the I Don't Know More movement know the depth of the problem we're facing in terms of what I call the determination plan that the federal government has. Because it is about the economy. They want to keep what they have, and they're trying to stop us from getting what belongs to us. That's the way I see it.